You understand you'll not have that hearing, and you'll proceed to circuit court for further resolution. Yes. People also waive their right.
Yes, Your Honor, there was an offer. Can I place that on the record?
Yes, you may.
The offer was to waive open exchange, not to add habitual offender notice.
Correct, Your Honor.
Correct. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We'll waive formal reading.
Thank you.
You're welcome.
Thank you for doing it right. I could count on you. Go ahead.
Thank you, Your Honor.
David Rogers.
You're waiving.
Yes, Your Honor.
Mr. Rogers, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing, and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor, there was an offer. Can I place that on the record?
Yes, you may.
The offer was to waive open exchange, not to add habitual offender notice.
Correct, Your Honor.
Correct. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. We'll waive formal reading.
Thank you.
You're welcome.
Thank you for doing it right. I could count on you. Go ahead.
Thank you, Your Honor. And we would stand mute and ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 with Judge Moon.
June 22nd, 2026, 1:30. Judge Hamoud.
Thank you.
Bond will continue. Thank you, sir.
Thanks.
And then on behalf of the people, Your Honor.
And Stephanie Cannon on behalf of Mr. Harvey, who's appearing. Could you say your name for the record?
Edward Harvey.
Your Honor, today's the date for set for examination. At this time, for unable to proceed as to count one, would ask for count two to be removed down to district court.
Your Honor, we have no objection to count two being dismissed.
Count one.
Time.
Count one being dismissed.
Yes, count one to be dismissed, Judge Vernon. Count two can't be dismissed. That's right.
Being able to proceed on count one. Count one is dismissed. I'll continue the defendant's not guilty plea to count two. Set pretrial in this matter for
May 7th at 9 a.m.
May 7th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor. Your Honor, my client has made a request that with the felony being dismissed, if the court would be inclined to allow for his phone privileges to be reinstated. As the court is aware, they initially revoked his privileges based on some communication. I believe information and emails have been received by the prosecutor letting them know that the complaining witness is not willing to move forward on this. And that at that point, she believed that she had anxiety and a psychological issue as an email I received, which was what led to this. So we're just asking that his privileges be.
But his privileges were revoked because the underlying offense was to domestic violence.
Yes, Your Honor.
So that hasn't changed.
Yes, Your Honor, that is correct. That is being remanded down to district court.
Is there a response from the people?
Violated no contact order with the victim by calling her and community. But unless they were made revoked.
Motion for bond modification is denied. Bond will continue and his phone privileges remain revoked.
Thank you.
Bond will continue. Thank you.
Thank you, Your Honor.
The preliminary examination, are we ready to?
After the examination, and this is anything, however, after the first, asking for 15 minutes, given that there's 3 minutes amount of discovery that I have not even been able to review as we received it this weekend, and that defense counsel does not have yet. I created a discovery packet for it yesterday in the court. I may remember set this exam last week, and inform the people that they may be able to start or continue the exam based on that. I have concerns given that this discovery includes potential video or surveillance footage of the assault, the victim's medical records, follow-up interviews with the victim and the victim's mother, and then the contact that would be jail calls and screenshots as well of outside contact. And I have not had a chance to review any of that, and I don't defense counsel has either. But this time I would ask you to start the exam with one of our officers, and then if anyone's given that.
This game.
Yeah, so first of all, I have explained all of that to my client, and he is aware that I have started listening to the jail calls, that I do not have the medical records, and that
Go ahead.
and that
But just so that I'm clear, these are medical records regarding the child. Oh,
that is true. And anyway, so I have received and looked at some, but I have not received all and have not been able to get through all. He is aware of that. He believes that this is, he objects to the preliminary examination as well as to a continuance because this is the date and time scheduled for the preliminary exam. If the people are not ready, then a dismissal today does not harm the people. A dismissal would allow them to continue their investigation and get all the information they need and not deprive them of his liberty rights while they continue the investigation, as opposed to being ready in the statutory framework.
And Your Honor, just for the record, if the case was dismissed today, the people will be reauthorized.
Yeah, I mean, that's what I was just gonna say. I mean, the reality of it, which is why when people are trying to rush things, it doesn't always work. If I grant your request, your client would understand that, let's say I dismiss it. Within a matter of minutes before he even goes downstairs, they're gonna be back here and it's gonna be reauthorized. And then the whole clock starts again.
We're aware of that. That was just a- So he acknowledges that and has not asked any question. The other point to our request for a dismissal at this time is that we believe that they are proceeding in this fashion because they are in fact not ready with regards to all of their witnesses.
I'm sorry, say it again.
That they are not ready with regard to all of their witnesses, specifically the complainant, and that this is to prolong this.
Wants to.
He does have.
No, go ahead. Just make sure to hit gonna talk to, yeah, just make sure to hit that.
His next question, and I did say that, and I did not get a chance to find out when the next available date for court, because if the court is going to grant their request, he's asking for the shortest possible.
Right, and just so that you're aware, counsel kind of let me know that this might be happening. And so I was looking back there. I didn't know entirely what defense's position would be. And maybe so that you compare the two. I'd say that if I did, today is the 28th. If I dismissed it, swore it out, reauthorized it today, he wouldn't get a PCC until the 7th or the 14th of May. And then an exam would be set after that. So you'd be looking somewhere around the 19th is the quickest that I could probably do with either one of them, right? So it'd be the 19th. Safely, you could look at it if we went that route around the 19th. I could, and I got dates sooner than that. But then the question becomes, with the information that, go ahead, Ms. Gaines, he's trying to tell you something.
Please.
Okay. With the information that's coming in, you said it's voluminous. So how fast can somebody legitimately get through that information? Because Ms. Gaines has not seen it, hasn't shared it with the client.
I would think for my review and then being able to, I would make sure that it gets to defense counsel today. There is a disc that needs to be picked up from our office. But the discovery as far as the subs and the evidence that come, I would think 2 or 3 weeks at the most.
2 or 3 weeks at the most.
I think 2 or 3 weeks would be appropriate to give me time to go through the subs and the media that has come in.
And Ms. Gaines, you don't have, I mean, you don't have an idea because you don't have it, right?
Correct, I'm not. No, can't say how long the supplemental, those things. Can say that I am viewed. Some, I don't know if it's all of the video that I am anticipating will be some of the supplemental reports, but I do not.
You don't have the reports, but you reviewed body cam that may constitute those.
That
Is that what you're, okay.
I don't know if that's all of it, but that I have reviewed.
So is the big part of the packet that you're talking about, is that medical?
Well, there's medical record drive, there's also surveillance video from the Walmart and the Meijer in regards to the assault in the parking lot. And then there's also a follow-up interview that was done with the victim and the victim's mother. And then one of those stuff is also the jail calls, kind of parse them through.
Okay.
But that is, and that's what it is.
And I did see what I believe is a bit in, was able to show my client what is the video for Walmart. I did not see video for Myers, so that would be video that you have not received yet, or
That's on the gets.
So the Walmart, just taking that piece, the Walmart video has been turned over. You've been able to show that to Mr. King. The other video, you haven't been able to show it to him.
yes.
And I have not been through that yet.
You haven't.
Part of my concern on Thursday. I haven't really been able to review any of the additional discovery that we received yet.
Well, I'd frame it this way. If I'm looking at if it were dismissed, reauthorized, I'd be on the 19. I'm also trying to balance everybody being able to look at it, Mr. King being able to see everything. And I'm going based upon the representations of the information that's there and being able to process it. All right. If I went to it doesn't sound to me like everybody's going to be able to get through this in 6 days, right? So then the next choice, I'll cancel or move stuff. I can do the 12th, not my normal day. I can do the 12th at 1, which would be a week off of when I would do it if it were dismissed.
We had Judge Companies for later. I just bring the disc to one of these there to bring back to Ms. Gaines today as well. So they don't have to.
Got it. So they don't have to come over and get it. You can get it to them.
Correct. If that would be easier.
You can get it to them today, the disc part. They don't have to go over and pick it up. Okay.
And I'll make sure that subs and other things with Cartel is sent over today as well. So everything hopefully should be over today. I can have my.
That's where we would be, because the problem is if I set it for the 4th, we're going to get back here. We're going to have the same darn problem. And so bottom line is given what everybody's told me, I can speed it up a week from what would be a dismissal. Ideally, even if we proceeded with the one witness today, began it, then I wouldn't adjourn it out past that same date, the 12th. So I mean, that's where we are.
So he is objecting to the 12th. He would like to either have it dismissed today or to have an early.
And that,
court date.
but
I
he
understand.
doesn't get the dismissal. I mean, that's the problem. So, rather than going around, I don't have to try to accommodate anything. I can just have them call their witness, do it, and then I can adjourn it out to whenever I want to. I mean, I'm trying to get him in as fast as I possibly can, but I'm not, if I'm gonna be hard-headed about it, I'm not gonna deal with it. So here's what I'm gonna do. You need to turn around. You can take him back, Ms. Gaines. You can talk to him. You can decide then what you want to do, and then I'll make my call on it.
Thank you.
We're past the matter.
Public defender, with and on behalf of Mr. King. You have one quick moment, please.
Say. You may.
Thank you. Your Honor.
All right. My understanding is that the people are ready to proceed with one witness. We're requesting an adjournment. I have indicated to parties that I would let the people do that as opposed to any other remedy the court may have. And then I would adjourn it out to May 12th at 1:00, which would be my earliest date, taking into account the additional discovery. My understanding, if I follow that procedure, there's no objection on behalf of your client to that.
That is my understanding from Mr. King. Is that right, sir?
I need a verbal response. Okay. All right. You may call your first witness.
Officer Charro to the stand.
Sir, please come forward and be sworn.
Testimony about your Thanks for your first and last name, just record clear.
Officer Cameron Traywa, DRIER,
Okay. You may inquire.
Thank you, Your Honor. Officer Charweiler, what do you do for a living? And how long have you been employed there? Okay. So I'm going to direct your attention to April 12th of 2026. Were you working that day? What shift? Were you in a marked patrol car? Were you in uniform? Okay. And were you dispatched to the area of 7000 East Michigan Avenue? And is that in Pittsfield, Washtenaw County, state of Michigan? Thank you. And what was the nature of that dispatch?
I originally was dispatched there. So right there, I got canceled due to the subjects leaving.
And when you arrived at that scene, did you come into contact with anyone? Okay. In relation to that dispatch, did you eventually come into contact with someone? Who was that? Okay. And when you met with him, how did he appear to you?
He was his stated.
And did you notice any injuries on Antonio Jr.?
Yes. Was
Okay. And did you take any photos of these injuries? And Your Honor, may I approach the witness with People's Proposed Exhibits 1 through 5?
No.
Thank you.
Thank you, sir.
And what did I just hand you? And those are the photos you took of the injuries on the victim, Antonio King Jr. Okay. And are they fair and accurate representation of the injuries that you observed on Antonio King Jr.? Your Honor, the people moved to admit People's Proposed Exhibits 1 through 5.
Any objection or what?
Your Honor, I would just object pending a foundational.
All right. pause here. This is where things get serious. The prosecution is now introducing physical evidence, and in court, that changes everything. These exhibits, basically photos, are meant to support the claim that an incident actually happened. But here's the key. Evidence is not just shown, it has to be proven reliable and relevant. That's why you'll soon hear the defense object. And think about this. If these photos are accepted, they could strongly influence how the judge sees the case. So the big question is, will this evidence hold up under scrutiny, or will the defense find a way to weaken it?
I'm trying to make sure I say this exactly.
Okay.
Pending there being foundational testimony from the individual with regard to how these are relevant to the charges.
So you're objecting based upon relevancy, but
Yes. But I also am under the understanding that they are going to be bringing more witnesses.
yes.
And so I would object for now, but if they're able to show it at a later date because of the agreement that we've
All right, okay, I guess. So what I'll do is I'll conditionally admit them for the purposes of questioning, subject to the continued objection to the relevance.
Yes, sir. Fine. Thank you.
Thank you, Your Honor. May we publish those to the court?
Yes, you may.
We're gonna hand those up to the judge.
Thank you, sir.
May I have one moment, Your Honor?
May.
When you came into contact with Antonio King Jr., where was that at?
Originally was in like the HBA area.
Nothing further this time, Your Honor.
Any cross-examination at this point?
Please.
Yes, you may.
Your Honor, at this time, I do not have any questions based on that examination. I would ask that Officer Trylon, did I say that very wrong? Trylon, that be available if I were to need to call him.
Understood. Understood.
Now this is a subtle but powerful legal moment. The judge says the evidence is conditionally admitted. What does that mean? It's basically a temporary yes. The evidence can be discussed for now, but it's not fully accepted yet. The defense still has a chance to challenge it later. This is how courts balance fairness, allowing the case to move forward while protecting the defendant's rights. And notice the strategy here. The prosecution is building momentum piece by piece, while the defense is carefully keeping doors open to challenge everything. So as this case continues, watch closely. Will this evidence become the backbone of the case, or will it fall apart under pressure?
So you have no questions at this time. However, you're reserving the right to recall this witness. All right, very good. Thank you. You may step out. All right. We will have no further witnesses for today.
Not for today, Your Honor.
The preliminary examination having been started as I had previously adjourned for the continuation of the preliminary examination, May 12th, 2026, 1 p.m. before me. Defendant's bond will continue. Thank you.
Thank you.